Hi, Antonino. Thank you so much for doing this interview with me today. Really, really great to see you again. How are things?
Hi, hi, Daniel. It's lovely to see you again, and thanks for inviting me for this.
No,
I'm very well, and I think this will be fun.
yeah, no problem at all. I'm really really excited. As you've heard and as I've shown you, I've been doing a bit of research on the Artemis Accords. But
Hmm.
there's a bunch of things that I don't understand that need clarification. And I'm sure you encounter this sort of thing a lot. So really looking forward to hearing your answers. I guess the first thing that struck me when I was reading through the Accords themselves is exactly the scope of the Accords. Like who is covered, who isn't covered. What sort of agencies or entities or activities are actually fall under the Artemis Accords to begin with.
Right. So that's a wonderful question to begin with, Daniel. And let me also tell you that indeed you're not the first one having troubles understanding the Artemis Accords. And I also want to point out this is not a criticism to the document. It's just that it is a complex document in with many layers that has to be understood within a certain context. So in itself, the accords might be read in a certain way, but if you see them in a systematic manner in connection with the Outer Space Treaty and in connection with other initiatives at the international level, then they acquire a whole different meaning. So that's also the reason why it's not too easy to read the document, even though it is in itself a readable document. It's not something that it's not impossible to understand on a language level, but the meaning and the implications require a certain level of knowledge that obviously the average person doesn't have in space law and international law.
Right.
So having said that, the document refers to the activities conducted by civil space agencies in the signatories countries. So the purpose of the Artemis Accords, as the name of the document also suggests, was primarily to regulate the civil space activities on the moon and Mars as part of the Artemis program. So the core idea behind the Artemis Accords is if you want to join the Artemis program, you have to commit to a series of principles that ensure that you are a responsible actor in space, essentially, and with specific reference to deep space exploration. So one thing that has to be clarified up front is that the Artemis Accords do not apply to activities in Earth orbit. They apply from beyond that
Okay.
because they are meant to regulate deep space activities, as is the Artemis program.
Okay.
Then, when the countries were negotiating the accords, they also realized that, of course, why limiting this only to the moon and Mars? Certain countries are doing activities, as you know, on celestial bodies further than that, and in particular asteroids. Japan is a great example of this. And so the idea was, let's extend it to anything we do as governments, as space agencies, in a civil manner, so without any military purposes, also because they are forbidden on celestial bodies. Let's extend that to any activity we do in the solar system, essentially. So that applies to the moon or to other moons, to planets, Mars up front, but other planets, and then comets and asteroids. And it applies only to activities conducted by governmental agencies for exclusively peaceful purposes. That means that commercial activities are left out from the scope of the accords in
Mhm.
themselves, but we will see that this is that there are exceptions to this general rule. And of course, the Artemis Accords do not apply to military activities beyond Earth orbit, also because according to the Outer Space Treaty, celestial bodies have to be used for exclusively peaceful purposes. So there is really, hopefully, no military activity whatsoever to conduct, and therefore there was no need to include any reference to that in the Accords.
Okay. So, I mean, that raises a couple of further questions. I hope you don't mind. I'm going to dive in here. Um,
Sure.
Obviously, the United States recently has set up a space force, right?
Yeah.
And if the Artemis Accords don't cover, as you say, they cover civil activities from civil space agencies. Um, there's increasingly a lot of things that could potentially fall outside of that scope. So, with the activities of Space Force, you mentioned that, like, activities on celestial bodies um, must be expressly peaceful.
Mm-hmm.
Um, to what extent does the Outer Space Treaty actually cover that though? Because in reading the Outer Space Treaty, it can seem a little bit vague as well. Could you go into a bit more detail on that?
Yes, yes, of course, Daniel. And it's a great question because the distinction between military and peaceful activities in outer space is always not an easy one. and one that requires us to understand that there are different rules applying to activities in Earth orbit and activities on celestial body. And that is under the Outer Space Treaty and under the Artemis Accords. So as we said, for the Accords, they only apply to activities beyond Earth orbit. Whereas the Outer Space Treaty in Article 4, when regulating the peaceful uses of outer space, has two different rules for these two different environments. So under paragraph 1 of Article 4 of the Outer Space Treaty, there are certain limitations on what military activities can be conducted in Earth orbit. And then under Article 2, there is an exclusive limitation to peaceful uses on celestial bodies. So the question becomes, what does it mean peaceful? There has been a debate on whether or not peaceful activities are simply non-aggressive or not at all military.
Right,
and
yeah.
there are several interpretations of this. The United States, for instance, but many other countries propose the idea that peaceful means non-aggressive. So if you're doing a military activity, you're not necessarily violating the principle of peaceful purposes as long as you're not committing an aggression towards another state. But all that discussion applies to activities in Earth orbit, because the limitation that you find in Article 4.2 of the Outer Space Treaty talks about exclusively peaceful purposes. And the addition of exclusively is meant to signify that not even just military activities can be conducted on celestial bodies. And so it's similar to Antarctica, where no military activity is allowed whatsoever. The same is on celestial bodies. So you will not see the United States Space Force conducting military operations on the moon, hopefully at no point in time, so as you won't see any military Space Force conducting these activities. Even though Article 4.2 has some exceptions that are not really exceptions. They are just more clarifications into, for instance, using military personnel for exclusively peaceful purposes. And that makes sense because some of our best astronauts in the history of space activities have been in the military. And so the idea was, let's not forbid these talented people to conduct activities just because they're part of a military branch, so long as the activity is exclusively peaceful in nature.
Okay.
So that's the main distinction. And I also want to point out one thing which completes this overview, which is the activities of the US Space Force, as well as of any other Space Force in the world, are focused on Earth orbit. And the reason is that they don't really shoot any weapon in space. Thankfully, they don't point lasers to each other. What they do is to oversee the security of their satellite activities. So the United States, for instance, again, has a critical network of satellite services that also have an impact on the national security of the country. And so the Space Force is there to make sure that these satellites keep functioning as they should, and that no one is interfering with that. So what these people really do is sitting in a room watching screens and making sure the satellites are working fine, that no one is jamming them, that no one is conducting a cyber attack on the infrastructure that makes the satellites function. And that's what the military meaning of Space Force is. They are not really conducting military operation in themselves in space. They're overseeing the strategic and military dimension of satellite and space infrastructure.
So very much space as a part of the sort of near Earth, the theater of Earth, right? An extension of activities on Earth, basically.
Exactly,
Yeah.
exactly.
No, that is interesting
sense.
to know.
And that makes sense because you don't see any military activity conducted in space. Every military use of space is always indirect. So we make use of the strategic advantage of space to conduct better military activities, right?
Yeah.
And then we can talk about what better means. Sometimes it means more precise, and it means that if you shoot a missile, instead of hitting any possible target, it's very focused on the target that it has to hit, and that is because of satellite technology. But
Right.
never in the last 55 years of space activities there has been a military operation as such in space. Everything has always been indirect. So that's also useful to point out, because you hear a lot about weaponization of space and people worried about weaponizing the moon, even though there have been some undertakings to show capabilities to destroy satellites. This has always been directed towards the satellites of each own country. So I am destroying my own, I'm not touching the others. And so until we go to the point that one country destroys the other satellite of another country, then we cannot say that we've seen any military activity in space.
Yeah, of course. I mean, there's always the chance for escalation and these sorts of rules to be sort of set aside for a variety of reasons. But it's good to know that at least on paper for now, those sorts of clauses and agreements exist. So thank you for clarifying that. I guess the other part of the scope that has really raised a bunch of questions comes down to commercial activities. So I had a read, as I mentioned to you, I had a read through both the Artemis Accords and also the Outer Space Treaty I've read before, and it seems to be that there's a bit of a gray area here, at least from an outsider's perspective, that the Outer Space Treaty forbids nations from making claims as such on celestial bodies, and that the Artemis Accords come in and say that or rather, sorry, it says it also says in the Outer Space Treaty that governments are responsible for the activities of non-government entities that exist within their border. So implying corporate entities and things like that. Whereas the Artemis Accords, while it doesn't specifically say free space mining for everybody, right? And anybody, all the corporate and private entities can do whatever they want. It does say that use of resources by non-state actors, I'm quoting exactly here, you'll have to correct me, does not constitute a claim according to the Outer Space Treaty. So it would seem to be creating a space there, perhaps not in contradiction of the Outer Space Treaty, but at least an interpretation of the Outer Space Treaty that would allow for private companies to come along and say, this is ours, we're going to be using this. And no, it's not a national claim, it's our claim. So would you be able to explain a little bit more about that and how it's being interpreted in the legal community as well?
Yes, that's a key question to answer. So thank you so much for that. And there are several layers to this. So I hope you'll forgive me if my answer is divided in different parts. Let's begin with how the Outer Space Treaty deals with private activities in general. Okay, so not only with specific reference to Article 2 and non-appropriation, but what is the role of private entities in space? What can they do and what they cannot do? Now, when the treaty was negotiated, the main addressees were states. When you look at Article 1 of the Outer Space Treaty, which is the provision that provides the freedom to conduct the exploration and use of outer space, it doesn't say space is free for exploration and use, period. It says space is free for exploration and use by states. It doesn't say by individuals. It doesn't say by humans. It says by states. So the freedom is only owned by state entities and no one else. Then the question at that point became, do we also allow private entities to conduct activities in space or not? And that's why Article 6 of the Outer Space Treaty was drafted. This provision is meant exactly to answer this question. And there were two perspectives at the time. There was the United States perspective, which wanted already to begin involve private entities in satellite activities. And there was a Soviet Union bloc, which didn't really trust private entities to conduct space activities because they realized that there were a lot of risk and potential catastrophic damage to be made. And they said it's better that this game is played only by the adults, and adults being states in this case. Then they reached a compromise and they said, okay, let's allow private entities to conduct space activities, but only with the authorization and continuing supervision under the international responsibility of a state. That means that if you do not have a piece of paper, you as a private entity, from a state that says you can do this, then you cannot do it. That's how it works for a private entity. You always need prior permission to conduct any space activity. And this permission cannot just be, as you already said, a blank check and say, okay, now go and do whatever you want. Because under Article 6, the state that gives you this permission has to supervise you throughout the whole activity. And it also has to make sure that your activity doesn't violate the Outer Space Treaty, and not international law in general. So this piece of paper has to say, yes, you can do this, and those are the conditions that you have to respect, and this is how I'm gonna supervise you, and this is what happens if you violate the conditions. This is ideally, obviously not every country is doing this in the same way or as accurately as they should, but ideally this is the regime. You want to do a private space activity, you need permission, and this permission has to be specific as to what you can do and include oversight mechanisms to make sure that you're staying within the lines, essentially. That's the general framework under the Outer Space Treaty. Then, specifically with non-appropriation, what Article 2 says verbatim is that outer space, including the moon and other celestial bodies, shall not be subject to national appropriation by claims of sovereignty and all the other means listed in Article 2. Now, when we say is not subject to national appropriation, the interpretation of the term national is broader than the average person might think. Because in international law, as we see also in Article 6 of the Outer Space Treaty, national means everything that at the end of the day is attributable to a state. And this includes state activities, as in public governmental activities, but it also includes the activities of private individuals, because at the end of the day, under international law, we all depend on our state. So national activities means state activities, but it also means activities conducted by the nationals of a state, and that includes citizens and commercial companies incorporated in that country.
You're right.
So
That's a very important thing to understand, I think. I didn't realize that going in.
Yeah, but that's normal. It's a technicism of international law. It's not obvious to the reader, but that's what they meant under Article 2. And so that's why private individuals cannot claim outer space and celestial bodies as much as states cannot, because the prohibition applies to everyone, to every single possible entity that exists on Earth. Obviously, maybe it doesn't apply to aliens, but obviously we don't have jurisdiction over them. And that's the Outer Space Treaty. Then we go to the Artemis Accords. And that's what I was saying before, that it's a little bit tricky, because the main scope of the Artemis Accords is the regulation of civil space activities conducted by civil space agencies. So in themselves, the accord do not apply to purely commercial activities. But at the same time, there are several clauses in the accords that tell you that if you, as a government space agency, are subcontracting a commercial entity to conduct your activities, then in this case, the accords apply also to the commercial entity. Or better said, you have to make sure that the commercial entity respects the commitment in the accords. Because
so, again,
in this
there's a line of
proxy.
Responsibility there, I guess, is the important thing. Yeah.
Because in this case, the commercial entity is acting as a proxy for the space agency. And so the accords make sure that you don't escape your commitment by saying, oh, but this is done by a private entity. It's not me, so I don't have to comply.
Right.
They're saying if this is part of a civil space activity conducted by the government, it doesn't matter who is actually performing it, you have to respect the accords. And that includes also activities with the use of space resources. And the term national appropriation used in the accords has to be interpreted in the same way that I just discussed for the Outer Space Treaty. So it includes every single possible user and every single possible type of claim. But let me tell you that no smart actor would try to circumvent this principle and find potential loopholes to say, no, it's not applicable to me, because everyone knows that outer space and celestial bodies are not appropriated. It cannot be appropriated. So it's much better to acknowledge that and say, okay, what can I do within these limits, rather than try and go on a fight that you will lose inevitably. The only one that managed to win this fight, because people don't really check what they receive, is this company. I think it's called Lunar Embassy or something. They began to sell pieces of lunar land to people that were scammed, essentially. They didn't own any title to the land, but they didn't really check what was written in the document that they were acquiring. And to this day, people sell pieces of Mars land or comets or stars, but in most cases, in this document you receive, it's always been like, this is for recreational
Yeah,
purposes.
there's
It's not a
probably
real claim.
the small text there is
Yeah,
kind of covers their bases a little bit, probably. Yeah. No,
yeah,
that's that again, very, very interesting to know. So, particularly the part about that line of accountability, I think, answers a lot of the kind of questions that I had rummaging around in my head. Because I know a lot of people think about this. They're like, what happens when the sector leans more and more and more into private sector activities, which obviously it's doing? What are the implications for that going forward? And, are all the treaties and agreements that we have up to this point basically becoming redundant at that point? And so, what you're saying kind of goes some way towards answering that question, right? That no, they're not.
yeah,
In short.
exactly. And
Yeah.
let me add one final thing, because when I usually discuss this topic, then I'm asked a follow-up question, which is, what about then rogue states, right? A
Yeah.
company going to a state that becomes a flag of convenience and
Sure.
says, yes, you can do whatever you
Yeah,
want.
I was going to ask what happens when somebody like you kind of asked it, answered it a second ago when you would just say, you were saying that people just would not try to push the envelope too much because it would open up a can
No.
of worms. The rogue state question is a similar one. Yeah. So what happens when a rogue state kind of goes
Well,
for it?
the short answer is exactly that. There is no incentive for state to behave like this because they are internationally responsible for the activities. So I was asked this question also during my defense of my PhD last month, and it is a good question in the sense that theoretically this can happen, right? If a state says, go ahead, then the state says, go ahead. But the others, the community will react to that. And so most of the time, this rogue state function is played by small countries. And these countries have no means to actually enforce the permission they give. So imagine that a small country gives this permission to do whatever you want in space, and then the United States, China, and Russia, they say, no, 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 you're not doing it. And then they're not doing it. So that's how it works. There is an element of peer pressure from the rest of the community that will make you comply, even if you're trying to take a shortcut. And on the other end, big countries like the United States, China, and even Russia, despite what we're saying in other environments, they will never do anything like that because they have reputation, they have infrastructure to protect. They don't want to risk it all for one space activity or for one private entity. They don't think it's worth it, right? The U.S. government has a certain standard to uphold, and the same goes to any important government, especially in space, where credibility is an important element.
Yeah,
And
sure.
so, in principle, in theory, it can always happen that a state sets up a very permissive national legislation and say, yes, come here, we'll let you do whatever you want. In practice, if you start messing up, the community will stop you one way or the other. And then we can go into how do you actually do it, but that would be a totally different conversation. But I can tell you there are means to make sure that people comply with the Outer Space Treaty,
Sure.
willingly or not.
So, I mean, that kind of leads into my next question as well. Now, obviously, the Accords, I remember when we were talking about this, I said initially that they seem to be quite vague, but you actually corrected me and said they're quite high level, right? And based on this conversation, I see what you mean, right? Like it's not that they're vague, it's that there's specific terminology used in a very intentional way. And because of the connections to other agreements and the general understanding in international law, they're much more specific than they might lead on, which is really, really good to learn about. But
Daniel,
yeah, sure.
If I just want to comment on that, what you said is exactly correct. But there is also another layer to this, which I think people often forget, that the Artemis Accords are not a final point. They
Sure.
are starting of a broader conversation.
That was going to be my next
that's
question.
where you were going to. Okay.
Yeah.
Sorry about
Yeah.
that.
So my next question was what do you think is the primary value of the Accords? I mean, that's a fairly broad question. But how do you think they can, should, or will be built upon in the future, right? What are the next steps? Because obviously, as you say, they're not a final point.
Yes. So I think the Artemis Accords are a great document. And I say that really from a neutral perspective. I don't have any particular interest in what the document does in itself. I'm not part of any government that works with this or space agencies, but I do think they are a useful document, and I do think they bring a lot of value to the table because they are starting certain conversations that we do need to have, and they also are an example of how do you conduct space exploration in a responsible manner. Because people fail to understand that if you have a multilateral group of states that is conducting an activity, you need rules. You need these countries to come together and say, how are we going to go to the moon? What are we going to do there? Why are we going to do certain things and not others? Who says what we should do? And because this is a regional limited, a core limited type of program, then it's for the parties to the program to decide what they want to do within the legal framework. And an example of that is the International Space Station. The International Space Station is a multinational endeavor. It involves several different countries, and it is regulated by an intergovernmental agreement. So the countries party to the ISS, they come together and say, we're building this thing, and what we're going to do about it? What are the limits that we want to follow? And why are we choosing this limit instead of this other one? And no one said, oh my God, this is illegal. It's meant to replace the Outer Space Treaty or something like that, because it is only normal that if you're doing something with someone else, you have rules, written rules. That's how society works. And that's what the Artemis Accords do. And they do it in a much lower level of intensity than the ISS IGA, because the ISS IGA is a binding intergovernmental agreement. It means that it can be enforced in court. The Artemis Accords are a political commitment. They don't go to the level of an international agreement. And the reason why they don't do that, it's too early for this. Several of the points discussed in the Artemis Accords don't have a final answer. Even space resources or safety zones, we don't really know how we're going to go about this in practice. So making an international agreement would have been arrogant because it would have meant, oh, we believe we found the final answer and that's going to be it. Instead, the political commitment says we commit towards this goal, but how are we going to go about it in practice is to be seen. And it is to be seen by the accords, by the parties to the accords themselves, but with the multilateral community too. Several sections in the Artemis Accords refer to multilateral discussions because, of course, these topics are not just discussed by the Artemis partners, they are discussed by the rest of the community. And so what the accords say is we're going to leverage our experience among ourselves to contribute to these multilateral discussions. And that means essentially that when countries are debating the regulation of space resources in Corpus, the Artemis group will go and say, we believe you can use space resources without having to appropriate a celestial body. And essentially, I think that's a good contribution to the debate. They're not saying, this is it, and we're not willing to listen to any other interpretation. They say, this is what we're finding in our own activities. So next steps for the Artemis Accords go in two different directions. There is the level of multilateral discussion that I just mentioned that will need to be dealt with in the multilateral forum, so the United Nations Committee on the Peaceful Use of Outer Space. So the very important points will continue to be discussed with the multilateral community. And then there are the smaller things, which essentially deal with the implementation of the accords in practice. And that will require implementing arrangements, so lower level types of agreements between the space agencies or with the space agencies and the companies and the other actors involved. It will require contracting, will require purchase and procurement. All those smaller type of agreements are going into the lower level. They're going into, okay, there is this principle in the accords. What does it actually mean in practice? And because it's a non-controversial principle, we need just to figure out the details. For everything that is controversial, meaning that is currently debated, then the answer will be taken at the higher level in a multilateral fashion, and then you will always circle back to the lower level, because at the end of the day, someone has to be paid for this service, someone has to negotiate a contract, and they need to put numbers in it, and that's what will happen at the end of the process. In case of non-controversial, we can take a shortcut and go directly to that part, and that's what is happening for landing, for instance, at the moment. But for more, let's say, sensitive points like resources or heritage protection, even safety zones, we need to go first up in order that we can go down.
Okay. No, that tells me a lot. on the subject of what value the Artemis Accords actually have, you've spoken to me in the past about you're a big fan of like the interoperability section, from what I understand, right? So
I
do you want
do.
to talk to me a little bit about interoperability and how important that is for the future of space exploration?
Yes, thanks, Daniel. That's one of my favorite parts of the Artemis Accords. I also wrote an article about it for Spacewatch Global some time ago because I really like when I read that in the document. So I'm not an engineer, so I'm here to explain you how interoperability will be done in practice. But from a policy and legal perspective, I really like the concept of interoperability because it is an enabler of international cooperation, and it is a safeguard of peaceful exploration of outer space. Because interoperability essentially means that we are able to plug into each other's systems. It creates opportunity for cooperating, and it reduces cost while making sure that instead of duplicating efforts, we can use whatever we have already developed on our own. So whenever we're going on the moon, hopefully we will not have to develop new landing pads every time someone lands. Maybe we will do that at the beginning to learn about landing pads. But once we know, okay, this is the best technology, we just have one, and people use that continuously. And the same goes for power. Once we have a power station on the moon that generates power, it makes more sense that people plug into the same system and that this system is built to be to allow people to plug in no matter the country they come from, rather than each one developing their own power system. And this goes for every technology you can imagine on the moon. And and through interoperability, we can also implement the principle that space exploration shall be conducted for the benefit and in the interest of all countries, and that exploration and use of outer space shall be the province of all humankind. Because again, it creates that community. It
Mm-hmm.
makes us relying on each other, and it makes sure that the benefit of what I have done will also be applicable to you, even though you didn't develop it. Right? That's in essence what interoperability unlocks to
So
me.
do you mind if I just not interrupt you? I'm really keen to sort of clarify something there, because what you raise I think is really really important, and I had not considered it expressly in those terms. That obviously there's a technical benefit, there's a sort of efficiency benefit to interoperability, right? And we see problems arising in things like the tech sector where there's like 50,000 different cables, or for cell phone chargers or what have you. So
My God.
those sorts of things are very obvious, I think, to a lot of people. But the community side of it, and the what you mentioned about it, making it more open and available to a wider group of people and wider sort of group, whether it's companies or other entities, to participate in the whole thing. They don't have to go out and develop their own proprietary technology or proprietary software every time they want to engage with space. So yeah, I mean that you're right. I think that is really really important. Is that sort of
Yeah.
thing happening already, like with around the Artemis Accords,
Well,
around
there
the
are
Artemis missions, I should say,
conversations.
not the Accords?
There are conversations about it, especially for the development of the gateway, to make sure that, especially plugging systems on docking systems, sorry, on the gateway are interoperable. Because right now, as you know, on the ISS, there are several docking stations that are only compatible with certain type of spacecraft developed by a certain nation. So
Mm-hmm.
what the idea for the gateway is, let's develop it in such a way that no matter the country you're from, you will always be able to dock it at any port of the gateway. So it is happening.
Mm-hmm.
And I can tell you, it is something that is driving processes for further development of technology related to the Artemis program. So this is extremely important with standards, right? When we're going to create the standards for lunar power systems or lunar landing systems or lunar transportation systems, resource activities, instead of going with the development of individual standards, the idea is to have multi-stakeholder global processes to develop one type of standards, or two or three interoperable standards that can work with each other. And the next step of that will be then having interoperable infrastructure that will be able to work effectively with all different technologies. And finally, and that's the community part that I mentioned before, which is an ideal step, but it's not necessarily a given, go from interoperable infrastructure to shared infrastructure, which means that you can come and plug in freely. And freely doesn't mean necessarily for free. It means that you are entitled to do that as long as you pay a certain fee. And then the question becomes, how much is fair for you to pay for that? Because obviously we don't want to give the impression that, you know, there's going to be one or two countries spending billions of dollars to develop high level, high technology, super expensive infrastructure, and then everyone else will just, you know, take advantage of it without doing anything else. That would be probably too much, right?
It would be
Because of
nice, but it would be
it'd be nice, but
too
I
much to
don't think
expect,
it
I
would
think,
be.
probably.
Yes, and also I don't think it would be fair. Like, I realize that, yes, as I said before, you know, space has to be conducted for the benefit and in the interest of all countries, but that doesn't mean that a group should abuse another one, right? It doesn't mean that you have to do everything and then the others can just expect to plug in. Also, because that would be bad. It would be bad for innovation. It would be bad for everyone just to pretend that, you know, the richest countries will do everything and we'll just sit down and then exploit it. It's not really how we want to develop a society and an economy on the moon. What I think should happen is that you have a fair fee to use it, right? You're not expected to pay for the whole cost that I had to sustain, but you pay for a small part of it, which is also an incentive for you to make good use of this. Because every time people get stuff for free, they disrespect it, they disvalue it, they think, oh, it's for free, so yeah, if it goes wrong, who cares? If you pay even sometimes a symbolic amount, I think that will be a good compromise, especially considering that some of this will be developed by commercial entities, and we cannot expect them to do this for free. We don't want them to do this for free because otherwise they will do it cheaply and badly. We want them to do something good. And then we want others to be able to plug in at fair conditions. I think compared to the other alternative, which is you're not going to use any of this and you will have to develop everything on your own, this is still much better. This will still allow many other players to participate in lunar development and exploration in ways that with the Apollo program they would have never been able to do, right? So that's, I think, the really added value of the Artemis program and the Artemis Accords. And the final thing is that things like interoperability show how much policy, law, and technology are interconnected, because we talk for 50 years about sharing benefits and international cooperation, and we drafted documents and declarations. But at the end of the day, a single concept like interoperability can embody all of that in practice. By doing it, then you implement whatever you have in policy. So I think it's the great example of, in space especially, yes, it's important to have framework, it's important to have laws and principles and declarations, but and at the end of the day, it matters how we do things. And that's why technology matters so much, because it's not neutral in itself. The way we develop a certain technology can help us implement better the legal framework we have.
Sure. I mean, I absolutely agree with that last part. In fact, well, a majority of what you would say, you said, I would say. I think there's a sort of philosophical conversation to have there, an economic conversation that I think goes beyond the scope of this particular interview. So we won't go into that.
No,
But
but let me just, if I may, Daniel, sorry to interrupt, but let me just tell that these conversations are important. And that's why one of the organizations I work with, the Open Lunar Foundation, is such a critical actor in space, right? And others too, because we're trying to foster this conversation because they're not just conversation for conversation. Their
no, that's true.
impact is real. And
Yeah, and
so,
it's happening.
yes, it's important that we focus on the details of a mission, but the way we frame those details matter, and we need to talk about it. And that's why the work that we are doing with the Open Lunar Foundation is so important to me, because it really fills that need that others are not considering. Because obviously, if you talk to a commercial player or if you talk to a space agency, they're very focused on what they need to do. They have a lot of work and they cannot really think about the philosophical question behind, but they are important, and it's important that someone thinks about them.
Absolutely. No, I'm a big fan of the Open Learner Foundation as well. And anybody listening to this or watching should absolutely go and check out all of the wonderful work that they're doing, answering some of these very real questions that need answers very quickly, actually, because all of this stuff is happening right now.
Yes.
You know, the touching, or rather expanding upon I won't say the issue of interoperability, because we agree that interoperability is extremely important from any angle, right? And it's to everybody's benefit. Actually, it allows innovation to occur more rapidly. It allows people to work together more easily, and in space, everybody needs to work together. It's not a friendly space in which to operate, right? So I'm going to ask about the other elephant in the room. We've talked about scope, we've talked about resources and potential military activities, and I'm really grateful for all the answers you've provided there. Obviously, and I didn't mention this in the other video piece, where I read through the Accords, because it's obviously just not part of them. But other major space powers are notably missing from the Artemis Accords. So these conversations around interoperability, these conversations around, like following the rules and all of that kind of stuff. Obviously, countries like Russia and China are party to the Outer Space Treaty, but they're not party to the Artemis Accords. And there are criticisms from other space powers that the Artemis Accords are being used essentially as a carrot to rather that the Artemis program is a carrot to get people to sort of sign on to the Artemis Accords, which can then form the foundation of future international agreements. So interoperability is really important. Cooperation in space is really important. Deconfliction in space is really important. All of these things are incredibly important, but anybody watching the space at the moment might get the impression that actually, where people have been cooperating a lot in places like the International Space Station over the previous decades, that it might feel a little bit like things are heading in the opposite direction at the moment. And the Artemis Accords might sort of solidify that perspective, given the fact that there are a selection of countries and not all major spacefaring countries like the Outer Space Treaty. So what are your thoughts on that, and what are the risks, and what sort of conversations are going on behind the scenes in order to mitigate that?
It's the question, really, I think, that at the end of the day comes out when we discuss the Artemis Accords, right? What about the others? What about China? What about Russia and everyone else in the world that wants to do space activities, but not necessarily under the Artemis banner or the Artemis program? Well, there are several layers again. I'm sorry about that. I'll try to make everything as smooth as possible. We have one unifying document, right? So the need for unification in space is served by the Outer Space Treaty and the other 4 treaties, except maybe the Moon Agreement. But we do have a legal framework that we all share. So we're all playing by the same rules in general terms. The question becomes, how do we implement these rules to new activities, like activities on the moon or space resources, things that are challenging the way we see the exploration and use of outer space, hopefully for good, but it can also be for bad, obviously. The Artemis Accords are an attempt to answer this question with reference to the execution of the Artemis program among a certain group of countries that think in a way. They are not meant to be a universal document. I mean, even though, of course, it would be nice, I guess, especially for the drafters of the Artemis Accords, who are colleagues and friends, to see as many countries as possible joining, also because the content of the Accords is essentially good content. It calls for responsible space exploration. So everyone should really abide at least by these principles, if not really by the Accords themselves. But they're not meant to be a universal accord. And the reason is that there's going to be other programs in addition to the Artemis program. This is not going to be the only program. And the example of that is the International Lunar Research Station, which is the initiative promoted by China and Russia for the conduct of scientific activities on the moon. Now, what do I expect is that at some point, there will be a document, a similar document to the Artemis Accords, saying, okay, those are the principles that we want to follow when executing the ILRS program. And then when we have this document, we can compare and contrast with the Artemis Accords and say, oh, they say the same thing. It's just one is called Artemis Accords and another one is called ILRS Declaration. Or we find out that they say different things. And then that will prompt a discussion in the multilateral forum to sit down and say, why did you say A and this other document says B? And then we talk about it, and hopefully we find a common ground for a C answer. And this will also come from countries which are not going to join the Artemis Accords, but they are not going to join also the ILRS. What we don't want is polarization. It doesn't have to be either or. It doesn't have to be that you have to choose a camp like in the Cold War times. It can be that you join both. For instance, the Artemis Accords do not forbid you to join any other initiative. And I guess the LRS will be the same. So there's going to be countries which are party only to one of this, countries which will be party to both, and country which will be party to none of them. And this difference in membership and composition is what will foster discussions that will, at the end of the day, find a way to reconcile these different approaches and documents. So it is not bad in itself that China didn't sign the Artemis Accords because they're not participating in the Artemis program. So it makes sense. But what would be bad if China or Russia, and now I'm not saying what countries should or should not do, but from a neutral expert perspective, it would be bad if they don't have any rules for their program, right? Which they're not going to do, obviously. They are already working on regulatory documents. They even want to make an agreement at some point. What would be bad is if in these rules they would say, we disregard the Outer Space Treaty, or we don't want to be responsible, then that would be bad. But if they come up with a different document called in a different way, which goes along the same lines of the Artemis Accords, in the sense that it tries to interpret the Outer Space Treaty in a cooperative and constructive way, then that's totally fine. And then we'll sit down and compare these documents and find common ground. That's what international diplomacy is about at the end of the day. It's not all of us, being part of one club. It's different clubs being able to talk to each other and not shoot missiles at each other. That's ideally what we want to achieve. And then for the basic things that we need to agree on, we have the Outer Space Treaty. And at some point, we will have other multilateral documents, which maybe will be born as a result of the common ground discussion between the Artemis Accords and the ILRS Declaration. And that's exactly what's happening at the United Nations. Last year, the legal subcommittee of the UN Committee on the Peaceful Use of Outer Space created a working group working on the legal aspects of space resource activities. And this working group has a 5-year work plan. And at the end of the 5 years, they want to develop a set of initial principles, ensuring that space resource activities are conducted in a rational, peaceful, safe, and sustainable manner. You can imagine those principles being the linking point between Artemis and any other program that is happening. Those will be the playing rules.
That's what I was going to ask. Yeah, so we imagine that there is the Artemis Accords, and then there is a parallel document or a set of agreements, and then what the working group is discussing, which obviously everybody is party to in some form or fashion. That could form the foundation of a bridging document,
Exactly.
where there's this difference in terminology. We've used this word, they've used that word. We're going to defer to the working group and their sort of in the collaborative efforts over that 5-year period in order to sort of find the middle ground and establish the next thing. I think that kind of goes some way towards answering my next question as well, which is what is the next thing? And I think that sort of coherently answers that question, right? And then the next thing is likely to be a bridging document between what these two. You're right. We absolutely don't want polarization. My concern, and probably your concern as well, is around the divergence in terms of interoperability between point A and point B, right? Between now and and then. If interoperability is really, really important, and we do want, whether it's private sector economies, private sector entities, or national space agencies developing different technologies that can all work together and allowing others to kind of use them or pay a fee to use them in environments like the moon. There's going to be some kind of divergence. I imagine there already is, right? Of course, we know that like the Soyuz capsule was used as a as a major vehicle around the International Space Station by both the US and Russia and everybody else for years and years and years. Do we risk moving away from the interoperability that we had over the next 5-10 years into a space where they're sort of two different tracks, and because of the massive expense associated with developing space technology, that we're kind of like stuck on those paths, and there's much more resistance to kind of like coming back together? I mean, what is the most likely scenario there? What are your concerns and hopes, I guess?
Well, it's a tough question. What you described is a potential future. It can go this way. and can go in the sense that we end up with two different programs that don't really have much in common with each other, but are operating in the same location. Because as you might have seen, when NASA announced the landing sites, potential landing sites for their first Artemis landing mission, it turned out that they overlap with the Chinese sites.
Right.
And then what are we going to do if they choose the same or two that are really close to each other, right? And that's an excellent question to discuss, and a point, I would say, an incentive for them to talk to each other, because at the end of the day, even though some people may be tempted to think it's going to be first come, first served, I'm going to arrive first and then I'll be fine. That really doesn't work like that. It doesn't. International space law does not give you this kind of right. It doesn't say you're there first, therefore you cannot be concerned by the others. It actually says you're there first, so you need to talk to the others because you know already what's happening. You have more information. So being first is not always a privilege. Sometimes it's a burden. And in this case, I think it will be like that. So this is a potential future, but we can avoid that future. And we can do it in steps, and we need the participation of different stakeholders. So I talked a lot about multilateral diplomacy in our interview, and I think that's, at the end of the day, that will be the decisive element, the decisive realm to solve many of the issues we have. But diplomacy is slow. It takes time. I said before, the initial principles of the working group, which we don't even know if it's going to be binding or not, will be ready in 5 years. And what do we do in the meantime, right? How are we going to go about the commercial activities happening already this year on the moon?
Yeah.
iSpace is launching in November, and China will launch again next year. What are we going to do with all this stuff? That's where I think the role of organizations like Open Lunar and in general civil society organizations, non-governmental entities come into play, because those players can be the neutral space for conversations among states, among actors, among companies, to make sure that while we agree on the bigger things, while we solve the big questions, we don't get lost in the details, and when we find a way to prevent that path dependency problem that you described, right? By controlling at least the level of divergence to an acceptable threshold, so that when we are ready with the general rules, then we can always contain it and come back and unify. That would be the goal between now and the next 5 to 10 years. That while the UN does its job and creates common ground for how do we interpret and apply the Outer Space Treaty to lunar activities, and space resource activities. In the meantime, we prevent any damage, any irreversible damage to happen with activities that are going to be held anyways, right? It's not that we're going to do nothing until the rules are ready, because that's not we want to work. We want to be able to begin, and pioneering activities also do not really need that level of regulation. But at the same time, it's important that we stay focused and we have that perspective that you said, okay, so that we don't make any choice that will prevent us to then reconcile with each other later on. So that's what is happening, hopefully should happen at the moment. There is a little bit of a void in this. So far, no organization has taken up on this challenge in real terms, like in saying, okay, I'm gonna start the first multi-stakeholder convening process on landing standards development or power systems. We do not have it yet, but I am positive that this will happen soon. I don't know which organization will be, or maybe I can tell you. Depends on how we look at this from different perspectives. But I do think that this should be the next step. That while diplomacy does its job, actors begin bottom-up processes to ensure the minimum coordination we need between now and then, essentially.
Okay. There's one, I should have asked this question at the beginning, because it's kind of like really leads into the discussion about the Artemis Accords in general. Going into this, my understanding was that the Artemis Accords were a bilateral agreement that the United States signed like wrote up and then signed individually one-to-one with a bunch of different countries. At first there was a selection of countries, and then others have kind of volunteered to sign on to it in the intervening time. But you were saying that that's not actually the case, because there's some debate, I think, about whether it's a bilateral agreement or a multilateral agreement. Do you care to clarify exactly what type of agreement the Artemis Accords are?
Yes, absolutely. I would say confidently that the Artemis Accords are a multilateral document. They're not a bilateral document or a set of bilateral documents. The first reason why you can say that is just looking at the document in itself. You find the original version of the Artemis Accords. It has all the signatures in one document, right? If it would have been a set of bilateral agreements, you would have had different documents, each with their own signatures. It would not be possible to do it the way they did it with all the signatures in one, because formally that would not be valid from a legal viewpoint. So the fact that everyone signed the same thing, it means it's a multilateral document.
Okay.
And the same goes for the negotiations. I cannot go into the details of it because they're confidential, but I had the same doubt at the beginning. Like, was it the United States coming up with the text and then reaching out to individual countries and saying, okay, this is it, take it or leave it, you know? Or was it an actual multilateral discussion among all the different signatories? And my understanding of it from the people that I had the pleasure and privilege to talk was that it was the latter. So the United States had the initiative, they had a core set of principles they wanted to discuss, but the whole document was drafted with the original 8 countries together, sitting at the table and discussing. And I think that shows the kind of document that the Artemis Accords really is. Yes, originally only a limited group of countries was selected, and I think that makes sense. Because if you want to negotiate a starting point, you need to start somewhere, and usually you start with entities that you think are like-minded, because obviously you want to begin. You don't want to be stuck in discussion that will not go anywhere. But then the document evolves, and people can sign it freely. As I said before, I do not expect China to sign the Artemis Accords, but if they want to sign it, they can do it. And none of the original signatories own the document. None of the signatories can say, oh, I don't want this country to join. And I think this is a very real argument, because it happened that I think Iran joined the Artemis Accords, and there has been protest by some people that said, oh, you should have stopped that. And for reason that I'm not going to touch upon, obviously, that's political discussions, but the point is that no one could stop it. You want to sign, you sign. You know, it's nothing we can do about it. As long as you are a government representative that is allowed to speak on behalf of your government, you can sign the Artemis Accords. And I think that means that in a way they belong to the world, really. They don't belong to the US. They don't belong to the original signatories, even though they created it. And I think that's really what it's supposed to be, right? It's supposed to be a document that the community can use the way the community sees fit. If you want to be bound by it on a political level, it's your choice. If you want to just take inspiration from it, then it's your choice. If you want to criticize it as well, that's great, because if you do it substantively and constructively, then we can improve. Obviously, it's not a perfect document. Not everything you find there is necessarily correct or will, stem the proof of time. But the fact that we discussed it substantively, it's good, because we need to solve these questions. The Artemis Accord began the conversation in a time where things were stalling and no one was making the first move. It was brave to do that, and I think we have to recognize it and then make the best possible use of it, which, as I showed, can be many possible uses of it, hopefully. So to me, that's how a multilateral document should really work. It should really prompt further conversations among those who want to sign it and among those who don't want to sign it, so that at the end we can make sure that the activities are conducted in a peaceful, safe, and sustainable manner.
Great. Thank you so much, Antonino. You've been amazingly helpful at answering a whole bunch of questions that I had going into this interview. So thank you very, very much for that. I'm just going to very quickly summarize a couple of because anybody who would have watched my research session would have seen me kind of encounter things. So let me just again very quickly go over a few things to make sure I understand some of the key points that have come out of the interview. As to the question of scope, and really this ties into the questions about military activities and resources and private sector activities and all that kind of stuff. There is a clear line of responsibility and accountability that is established between the Outer Space Treaty and the Artemis Accords. And whilst the scope of the Artemis Accords is not all-encompassing, collectively with the Outer Space Treaty, the activities of particularly military activities carried out on celestial bodies are, from what I understood, completely prohibited. And commercial activities are associated with the nation state to which they are conventionally associated according to international law here on Earth, right? So that, like, you know, if a private entity carried out activities on the moon or on Mars or wherever else, that they are held, that the nation state that they belong to is responsible for their activities and actually has to sort of be party to granting them permission and holding them accountable. That is,
Yeah,
do I understand all that
correct.
correctly? Right.
Yes.
In terms of whether it's a bilateral or multilateral agreement, you just answered that one for me. It's a multilateral agreement. In terms of like the key value of the treaty beyond what we just discussed, which is the agreement, shouldn't call it a treaty, beyond what we just discussed, interoperability is a huge one for all the reasons that you mentioned, right? Not only the importance of being able to work together just based on the environment that you're operating with and those sorts of strenuous conditions, but for innovation and for supporting continued growth and everything else. And making it, which I think this is a really, really important point that you made, opening it up to use from parties that might not necessarily, you know, opening it up to parties that might not necessarily be able to independently fund or develop their own technologies in order to participate in space exploration. So that's really, really cool as well. Yeah, I think that about covers it. Have I learned a thing or two?
I'd say so. Great job.
Thank you so much. Before we go, you mentioned the Open Lunar Foundation. Is there anything you want to say about the Open Lunar Foundation? I know that you work with them quite a lot. Do you want to just spend a minute or two talking about what they're about and what they're up to at the moment?
Yes, thank you, Daniel, for that. The Open Lunar Foundation is the non-governmental organization dedicated to sustainable and peaceful and cooperative lunar development. So the mission of Open Lunar is to make sure that when we develop lunar activities, when we look at the moon in 10, 15 years, when hopefully we have even humans maybe living there, we see something that we're proud of. And I think this can be done and is done by the Open Lunar Foundation in several ways. There are technical activities that we conduct. We support certain high-level research that is important to enable the foundations of sustainable lunar activities. But we also are actively involved in policy discussions, and we are also working with other actors. And we also give the community the tools needed for the community to answer these things themselves. And an example of that is the Breaking Ground Trust, which was established at the initiative of Open Lunar, but it became an independent entity to demonstrate policy in action for space resource activities. So it's the first example of trust solely dedicated to the use of space resources. And that's one of the contributions that I think Open Lunar gave to the space community. It didn't say, we are going to answer this. It's that let's create something that could be useful for that. And so there are several types of contributions that we engage in, but the goal is one. The goal is to ensure that we do not replicate the mistakes we have done on Earth, on the moon, and I think hopefully we are on a good track for that, and that we really create a better society for ourselves there. And that applies on so many levels. It means being inclusive, it means being sustainable, it means maintain peace, and at the end of the day, I think it means ensuring that prosperity can continue to happen in space and hopefully can be further enabled by the moon, which is something we are so attached to, at least I think culturally, emotionally, and to a certain extent physically from an astrophysics viewpoint, but not yet sociologically. And so hopefully the Open Lunar Foundation can contribute to that. And I'm very happy to be working with them on this many amazing activities.
Great. No, it sounds fantastic. Thank you once again for speaking to me, Antonino. Wonderful to have you and look forward to speaking again in the future. Have a lovely day.
Thank you so much. Thank you so much, Daniel, for this. It was really nice chat. And if anyone has questions, please feel free to share my contacts. I'll be able to and happy to answer any of further points.
I might link to your LinkedIn profile or something like that when mentioning you in the article. Is that okay?
That'd be great, of course.
Okay.
And
Wonderful.
Hi, and thanks everyone for listening in. I hope now you all know a little bit more on the Artemis Accords.
Yeah, I know I certainly do. Thank you so much. All right, see you.
Thanks.
Bye.
Bye.